Well, good morning, everyone. Thank you for joining. I'm Stephanie Giorgio. I'm the events manager with the Mississauga Board of Trade. I want to thank Kaiser Mason Ball for being our sponsor today and hosting this webinar. So I'll do a quick introduction and then we'll get started. So Amy is the managing partner at Kaiser Mason Ball Law, a member of the firm's corporate commercial group, and leads the firm's franchising, retail, and distribution group. She regularly advises a range of corporate clients, including local startups, family-owned businesses, and national corporations on all aspects of business law, with emphasis on franchise systems for both franchisees and franchisors. Sudeep is an associate partner at Kaiser Mason Ball and a member of the firm's corporate and commercial practice group, primarily focusing on franchise, retail, and distribution law. He advises new, emerging, and established Canadian and international franchisors on all aspects of Canadian franchise law, including the drafting and preparation of franchise agreements, disclosure documents, master franchise agreements, and manages franchisor relationships. So welcome, everybody, and I'm going to hand it over to Amy and Sudeep.
Hi. Okay, so we're going to talk about franchising. I think that for business owners who are looking to expand, franchising is a method that sometimes seems bigger than it is. So we want to make sure that everybody understands the basics in terms of how to franchise in Canada. And next slide. Okay, so we are lawyers. We just want to make sure that everybody knows that if you know what we're telling you today is really a high level understanding. If you have specific questions or specific issues, feel free to reach out to us directly or any of your own legal advisors. Next slide. So we're going to go today. I just wanted to first tell you a little bit more about myself and Septmeber and KMB Law. KMB has been in the Mississauga area for almost 45 years. And we have recently expanded to Burlington and to Markham. So we now have locations, offices in Mississauga, Burlington, and Markham, and we provide a full suite of business law services, really everything the business owner or the business could need from the start to the end of their business relationship, including family and estate law that is specific to business owners. Now, as Stephanie mentioned, Sudeep and I focus primarily on franchise systems, whether it's an international system coming into Canada, a Canadian system that is expanding, or an owner-operator, new idea that wants to start a franchise system from the ground up. So we're very comfortable with franchising, and we manage not only the creation of the system, the ongoing use of the system from a day-to-day, and also the termination of franchisees and the wind down of systems, and finally sales. We do work in the purchase and sales of systems as well. So like we've said, everything that relates to the franchise model.
So today's agenda, we'll start by covering off the basics of franchising, discussing what exactly is franchising, what is the Arthur Richard Act. We'll follow up by a discussion on the franchise disclosure package and how that works. We'll discuss the different structures within franchising. In relation to that, we'll touch on what you can expect in terms of legal process of trying to set up a franchise system here in Canada. And lastly, we'll touch on the overview of the different franchise agreements if you are to get into a franchise relationship. So to begin, the basics, and a lot of questions we get from potential customers, clients, referral sources is what is the difference between franchising and licensing? So today's discussion is solely based on franchising. It is a form of business investment and ownership governing the distribution and sale of goods and services. So essentially, a franchisor, the party that has developed a business system in association with the trademark, they license the use of that system to a franchisee for a certain period of time. So within that, the franchise system that's been developed, the franchisor essentially exerts control over the franchisee. This is different from licensing. Licensing is more so focused on the license of a brand and trademark to a third party, but without that exertion of control. If there are specifications, there are standards, there are rules that a franchisor requires their third-party investor to abide by and follow, then it is very likely that relationship falls into franchising and not licensing. And if it does fall into franchising, that takes us to the second part of the slide, is the Arthur Wishart Act will govern that franchise relationship. So in 6 out of the 6 provinces in Canada, there is franchise-specific legislation. This legislation essentially was enacted to protect investors that are investing their hard-earned dollars into franchise systems. And the government thought it was, all the provincial governments thought it was in the benefits of consumers to enact this consumer protection legislation to help them, to help protect their investment. So franchisors, before the act was brought forward, they were selling XYZ, but without rules and standards that the government had legislated. These rules and standards were required because a lot of people were spending money into franchises, weren't being provided the proper disclosure into the background of the franchise they were investing in, and people at the end of the day, unfortunately, were losing their investment. So today's discussion will focus on the Arthur Wishart Act, which is the franchise legislation that governs the province of Ontario. So the Arthur Wishart Act governs the relationship between a franchisor and a franchisee. So any obligations on the franchisor in regards to what requirements they have to fulfill in their disclosure documents, in regards to the costs, the process, all of those have already been legislated, and a franchisor, in order to franchise and sell franchises in Ontario, must abide by the Arthur Wishart Act.
Okay, so as Suki mentioned, really the Arthur Wishart Act says a couple of things. It says we want to make sure that people who decide to be franchisee owners in Ontario, and again, we're focusing on franchisee units that exist in Ontario. If you are an Ontario system and you are bringing on franchisees in Alberta, which is certainly a possibility, the Alberta Franchise Act would govern. So the act that governs is the location of the unit holder. So where your location will be, where the franchisee, where the coffee shop or the burger store or the daycare will be located. So again, when you get into franchising, often our clients will care about all franchise legislation in Canada because they set up their system to be coast to coast. Many start in one province and expand slowly, and some start to finish coast to coast. So many of the legislation, much of the provincial legislation is all very similar. So a lot of what we're talking about will be very similar to what you would be hearing if we were talking about British Columbia or Alberta or the other provinces. But the details are very specific to the province that you're in. So, make sure that if you are going to take what you're learning today and apply it to BC, that you do speak to BC Council or somebody who does do national franchising, who can handle the coast to coast discussions. And again, we can certainly have those conversations with you. So the Arthur Wishart Act, it does two things. It provides prospect franchisees with information about the franchisor, about the system, and about what you can expect in terms of costs. And it provides some rules about how you get that information and the relationship between the franchisor and the franchisee. The most important thing the Act does is it requires that all prospect franchisees receive what's called a franchise disclosure document. It is a lot like securities law, although a lot less complicated, in my opinion, than securities disclosure. So every prospect franchisee is entitled to be provided with a franchise disclosure document. Those disclosure obligations are very specific. There's a very specific list of what you need to provide prospect franchisees under the regulations of the Act. And that would include things like a list of any litigation that you've faced, any bankruptcies you would have to list if you've gone through a bankruptcy. You'd have to provide background about yourself and the brand, if the trademarks have been registered, if they're not. And then, like I said earlier, you have to provide a lot of cost information. So how much is it going to cost the prospect to become a franchisee? What can they expect in terms of startup and investment costs? And that does have to be very accurate. In addition, you'll be provided with copies of any documents that you'll be expected to sign. So that entire package, the provision of it and the timing and delivery of it is all very specific under the Act. But it's important to understand that it's not a huge, in the States, there are registrations. You have to put these documents together and apply for registration. It's a very long and expensive process. In Canada, that's not the case. And none of the disclosure provinces require registration. So what that means is you just have to make sure that your franchise disclosure document is in line with the Franchise Act of that province, and then you're ready to go. There's no kind of extra step of getting it certified in any way, which takes, which speeds up the speed in which you can start providing these documents, and it obviously lowers the cost as well. So timing, the prospect franchisee has to have this complete document for 14 days. They have to have been provided that document as per the Act. So often in this day and age, the Act has been changed since its inception. We now can provide those documents electronically. So you can provide them electronically. There is a very specific way of doing that. You can't provide links to other things. They all has to be really in a PDF attached to an agreement, attached to an email. And anything that comes within that disclosure period. So that, again, that disclosure period is, when we talk about the disclosure period, we're talking about the timing from the date you receive, the prospect receives that franchise disclosure document, or FDD. We'll start to refer to it as an FDD throughout the process, throughout the talk. So from the day you receive your FDD to the day you sign up as a franchisee, or you say, you're no longer interested, that's what the disclosure period is. That period has to be 14 days or more. In my experience, that typically is longer than 14 days. Typically, the prospect will take it to a lawyer, will talk to them. Depending on the brand, they will negotiate some of those details, and eventually we'll create a company, we'll create a franchisee corporation, we'll sign up. And usually, like I said, that has to be 14 days or longer, but typically it's around 3 to 4 weeks that you kind of have that outstanding period of time. Once you get a little bit longer than that, you do risk things changing. So again, that comes back to the statement of material fact. If anything in your system changes from the time you provide that FDD, but before they become a franchisee by paying and signing up, you have to give them a statement of material fact. So the most obvious example is if in that period, the prospect finds a location, you have to give them information about everything that's going to be material to their system. So if the location they found changes the costs that they can expect, or changes some detail in the franchise disclosure package, then you have to provide a statement of material fact that provides this updated item. A material fact is really anything that the franchisee would say would have led them to make a different decision. So had they known that legislation was going to change the way you become licensed in a daycare, they may not have decided to sign up with this new daycare brand, as an example. Rescission is definitely the worry of the franchisor, and that really is just what would happen if you provide a non-compliant franchise disclosure document. So if you provide the prospect franchisee without an FDD, or with an incomplete FDD, the prospect would have a period of time to back out of that agreement and act as if the agreement had never been signed. So there'd be no ongoing obligations of non-competes or non-solicits. They would get all of their money back from the franchisor, and in fact could claim back money that they had spent on the brand or on the business to the date that you rescind. Now, that date is very important. There are 2 dates that the legislation provides for. There's a 60-day date. So 60 days from the time that you become a franchisee, you could rescind the contract. You could back out of the contract and claim all your money back if you were provided with a partial FDD. So something was missing. More often than not, that is not where, people don't really find out they want to back out of a contract within 60 days. That is a very unused piece of legislation. More often than not, we're talking about a 2-year rescission. And that is certainly long enough for people to understand that they may have made a bad decision, or that the investment was not what they expected. And so the ability for a franchisee to back out of the contract within a 2-year period, a 2-year rescission, would mean that the franchise disclosure document would have to have been, would have to be so deficient that it was as if they didn't get it. Now, or if they didn't get it at all. So many franchise brands who don't have proper legal counsel just provide a franchise agreement, signed up, they're paid for, and then, a year and a half later, the brand doesn't do well. That would be a perfect example of a 2-year rescission. There was no franchise disclosure. There was no disclosure provided. They have a 2-year window of rescission. But case law has been certainly busy since the franchise legislation in Ontario existed. And so there are certain flaws that are what are considered to the court as a fatal flaw. So something so significant that just this one thing missing from the franchise disclosure document would be sufficient to be equivalent to not receiving it. So, for example, the franchisor has to provide a copy of their most recently completed review engagement level financial statements. If those financial statements are missing, it's as if the franchise disclosure document was not provided at all. Also, another one that does seem often to people like a minor issue is if the document is not signed. If the document is not signed, it's as if it was not provided. By signing that document, the franchisor is confirming the contents of it are accurate and complete. So without those signatures, it's as if you didn't get it. So certainly if you have questions, if you are somebody who's listening who signed a franchise disclosure, who signed a franchise agreement and who is second guessing and you're within that 2-year period, certainly reach out to legal counsel before you pass that 2-year period, because if you have been a franchisee for 2 years and a day, even if you didn't receive any sort of disclosure at all, you would not be able to rescind. It is limited to 2 years. Another thing that the Arthur Wishart Act does is it provides a duty of good faith and fair dealing amongst the parties. So not only the franchisor to franchisee, but franchisee to franchisor are obligated to work to interact with each other in good faith. This would not be the case if it was just a normal contract. And really that just means that each party has to consider the other in their decision making. There's a lot of case law around this and it's very fact specific. So certainly reach out to proper counsel if you have a question about that duty. And then it does provide the franchisees with the right to associate. That just means that your franchisees can talk to each other. You can't tell them not to say certain things about the brand or about the deal that they got. And in fact, you do have to provide a complete list of your current franchisees and your recently past franchisees. So franchisees who've left the system for any reason in the recent past would all have to be listed with current contact information in your franchise disclosure document. The intention is really for all prospects to be able to reach out to current and past franchisees to find out what it's like to be a franchisee of this system.
So what structure is best for you, the franchisor, in regards to selling these franchises to the public? So there are two common models here. One is a single unit franchising model, which essentially means the franchisor will be selling a single unit franchise to an individual candidate every single time they onboard and sign and prospect up. This is probably the most typical and the most common. Growth does happen 1 unit at a time. And in certain circumstances where you have a sophisticated franchisee or somebody wants territorial rights to a certain location where they believe that they know that demographic, they know that geography, that they want 2 to 4 units or 5 units, whatever that number may be, they may sign up a multi-unit franchisee, give them rights to multi-units within a specified territory. So single unit franchising is the most common form of franchising, but there is another way of franchising, and that is called master franchising. What this essentially states is, say there's a franchisor and they operate coast to coast in Canada, but they're from Ontario, they've done very well in Ontario, but they don't really know how the market is out west or out east. So they may grant master rights to a central candidate, say to British Columbia, over the entire province of British Columbia. That candidate would then become essentially the franchisor in that province. They would be responsible for creating their own disclosure document and selling franchises to candidates within that territory. Say it is the province of British Columbia. Obviously, in return for this, the head franchisor would get a piece of the franchise fees that's payable for all of the prospective candidates signed up in that territory. They would get a portion of the royalty fees, and potentially some advertising fund split may also happen between the head franchisor and the master franchisee in that candidate. What this essentially allows is a brand to grow faster, having knowledgeable, sophisticated people in certain markets that the franchisor may not necessarily have people or the resources or knowledge to expand into. This allows for the brand to grow faster and in turn strengthening the brand, strengthening the overall franchise offering to the public as well. But in taking into consideration that a franchisor may have given a master territory away, if a franchisor then thinks in 5-6 years that, hey, I now want to become the franchisor of that territory, it's actually too late. For the term of that master franchise agreement, the franchisor essentially has given away its rights to franchise in that province. Obviously, it would be subject to a master franchise agreement where the master franchisee candidate in the province does X, Y, Z that's against the terms of the agreement. There may be rights of termination subject to, if there's any cure period and so on and so forth. But essentially, if that master franchisee candidate has abided by all rules and hasn't defaulted under the master franchise agreement, it's going to be impossible for the franchisor to cancel that master franchise contract in that specified territory. There is another third structure of franchising that isn't mentioned up here, which is essentially it's a little bit of master franchising and it's a little bit of prospecting and doing sales, and that's in the world of area development. So say if I really know the Toronto market and I think I can help a franchisor develop that market, I may get certain area development rights where I agree to sign up 50 single unit franchisees in the territory of Toronto on behalf of the franchisor, but I necessarily will not be the head franchisor for each of these prospects. The head franchisor will still be responsible of giving a disclosure document directly and dealing with them directly in regards to their relationship. However, as an area developer, because I know that territory, because I helped develop it, I may get a cutback on certain franchise fee splits, certain royalties, but there also might be obligations on me as the area developer to train franchisees within my territory to provide them additional ongoing support. So there's a a third structure of franchising, but it's all to be determined based upon your relationship, the expertise, and the sophistication of a franchise candidate before a franchisor ever considers granting a master franchise or any sort of area development rights.
Okay, so the legal process. So we've talked a little bit about this throughout the presentation so far, but really what happens is whether you are average, so at this stage, the franchisor already has a franchise disclosure. You may already have franchisees in your system, or you may be trying to sign up your first franchisee. Really, the first 5 are more difficult than the second 5. And once you have about 25, it does become much, much easier. And that's really just a function of the fact that you have a more proven model. The first 5 are difficult because you're really asking people to believe in a system that may not yet exist in a way, and certainly not anything like the systems that we really know well, like the Tim Hortons and Boston Pizzas and the Burger Kings of the world. So you have a prospect, they somehow indicate to you whether they fill out an application online or they attend a trade show or they just reach out to you at your restaurant or your hair salon and they say, hey, if you're ever interested in expanding, I'd love to own one of these in Burlington. Interest is shown. So we recommend that at this step, you have some sort of application. The old days, everybody had an application. Currently, that is being passed for more of a interaction with the franchise system. So you may have an interview, you may have a Zoom call, you may meet for coffee, but you want to connect with that prospect to understand, A, if they have a financial and an educational background that allows them to really be able to run a business for you in your system, and also if they're the right fit. Depending on the brand, fit can be more important than anything else. So, do they believe in the type of philosophy that your system and your franchise also believes in? Are they going to connect with the product and the service? Are they going to be a good owner and operator of this new location for you? So if if the person who's reached out to you and is interested, you also agree would fit, and you've checked that box, and you provide them with an FDD. Now, this is what Septmeber and I do on a day-to-day basis for many of our clients. And again, that's because you want to make sure that the FDD is complete, it's up to date, it's been signed, and each of those boxes that need to be checked are done, and then it's provided properly. You can ask for a deposit. So one of the things about franchising is you cannot get any document signed, you cannot have any payment provided until you've completed that 14-day or more period. Now, there is an exception to that that's recently, in the last year and a half, 2 years, come into play in Ontario. It was previously allowed in other provinces, but Ontario made the change about 2 years ago. You can now take a deposit ahead of even providing that franchise disclosure document. So there are some rules about this. The deposit has to be fully refundable. No matter who decides and how long it takes them to decide they don't want to proceed, they need to get all of their money back. And the amount of deposit can only be 20% of what you're taking from the franchisee if they do sign up with you. So it is really limited, and many of our clients, when the legislation changed and we started to be allowed to have deposits, jumped on the deposits, and most of those clients no longer use a deposit method because it really is just an extra step that can confuse and complicate things. But if you do want to make sure they have skin in the game, you do want to make sure they're really interested and not just kind of kicking tires, the deposit concept can be a good way to do that. But in any event, we're going to get to the franchise disclosure piece, and that's when they're ready for the proper package, whether or not you've taken a deposit first. So we send them electronically their franchise disclosure document. They sign a receipt saying they've received it. That's important because you want to make sure we're all on the same page with respect to when that 14-day period starts. So when have they received that package? Now, if it's electronic, they have to be able to receive it, view it, open it, and read it. So they have to confirm that back to you that they've received it and that they can view and read it. Then you start that 14-day period. So once that FDD has been provided, you start that 14-day period. As I've mentioned a couple of times, 14 days is the minimum amount of time that period can be. It certainly can be more. And that's when the franchisee will take that package to proper franchise counsel, hopefully, and they will come back to you with some questions, concerns. A lot of that review will just be informational for them, especially depending on the brand. If you have a very strong brand with many locations, and it's been very proven, you will likely be in a position to say, no, this is a take it or leave it discussion. If you decide you want to buy a Tim Hortons, there's no negotiation. It's a take it or leave it situation. But for a lot of the brands we work with, we do work with some very strong brands that are national and international. And the idea is really there's no negotiation. But for a lot of our brands that are not like that, who have 20 or under locations, they do still do some negotiation. They may talk about the term. They may talk about the costs, they may talk about the dollar amounts, they may talk about specific pieces of the agreement. And it is a lengthy agreement, typically about 40 pages. So there's a lot to talk about and a lot to make sure the franchisee understands. In my opinion, you do want to heavily encourage your franchisees to get counsel. It can mean that you do have to deal with some negotiations, even if you don't feel it's appropriate. But the benefit is that you have franchisees who, at the end of the day, if they do sign up with you, will really understand what they're getting into. There's nothing worse than signing up a bunch of franchisees and realizing a couple months into your relationship with them that they didn't really understand what they were signing. And so it's really important that they are encouraged to get counsel, if not just to make sure they understand their rights and obligations to you and to the system. So as we mentioned, if during that period of time where they're negotiating and reviewing documents, something changes, whether it's something that they've, done, whether they found a location or they've decided to bring in a new partner who would be a guarantor, you may need to provide a material change statement, but we're still within that period of disclosure. Some brands will provide a discovery day. This kind of fell away during the last couple of years, obviously for, pandemic reasons. But in the old days, you would, get on a plane often and fly to wherever the head office of the franchise unit or the franchise system was. And you'd have what's called a discovery day. You'd learn more about the brand. You'd learn more about the philosophy of the products and services. You'd learn, and the franchisor would learn about you, more about your background and whatnot. In my experience, that doesn't happen as often anymore. More often than not, there's a series of, interviews and meetings and Zoom calls and whatnot, just to make sure that everybody's on the same page. And this, again, is all happening in that period of disclosure, that 14-day plus period. and no payment has happened yet. So that happens next, execution of the initial documentation. So now that you've had time to review and understand and potentially negotiate and meet with the team, and you know what you're getting into, and you've properly decided what decision you want. Do you want to be a franchisee or not? If you decide affirmatively that you want to be a franchisee, you're going to sign those documents. We're going to get into what those documents are a little bit later, but generally it's a franchise agreement and all the items that are ancillary to that franchise agreement. And you're going to pay your initial franchise fee. Sometimes there's additional costs that have to be paid at the time of signing the execution package or initial documentation. And that might be a deposit toward build out costs. If the franchisor is going to build out your location on your behalf, it could be costs related to equipment or assets that you have to purchase that need to be ordered. But generally, we're talking about an initial franchise fee, and that ranges really from about $20,000 to all the way up to $150,000, depending on how big a location or if you're buying a master. But generally, for a unit, we're talking about something like $20,000 to $40,000. Now, if the franchise system has used a broker to help bring on those prospects, a big chunk of that initial franchise fee will be payable directly to the broker. So the franchisor really does need to set that initial fee based on their costs. So it should really be able to cover the entire onboarding costs. So it should cover the training. It should cover the onboarding costs, whether that's broker fees or meetings that the franchisor has had to fly to talk, to spend time. It should cover their legal and accounting costs. To get those documents in the hands of the prospect, now franchisee. So the payment is made, the documents are signed, you have a franchisee now. The franchisee will really just do next steps between that time and when they're open for business. So is it a brick and mortar location? Will there be a lease that has to be signed and a build out that has to be completed? You have to locate the location has to be determined. The lease has to be negotiated. Do you sign the lease? Does the franchisee sign the lease? Those are all things that we'd already know, and the franchisee would already understand what the next steps would be. Very flexible. Many franchisor brands sign the lease directly. Many franchisor brands allow the franchisees to sign. So locations determined. The build-out will happen. Now, lots of franchises don't have a location. Lots of, tutoring companies, lots of healthcare, quasi-healthcare companies, may just be a home office business where you, as the franchisor, are connecting your service providers with your service, with your clients. And then the location has to be operational. So you'll train your franchisee. You'll help them understand, what they need to do next. The franchisee will have to complete their build out, make sure it's done and ready to start. They'll have to make sure they've purchased all the equipment and assets and inventory that's needed. Now that they've been trained, they'll have to make sure they've hired their own staff and employees and they've trained their own staff and employees. So it's important to understand that once the franchisee is operational, that business is the franchisee's business. It's an incorporation that franchisee owns. The employees are the franchisee's employees. And the suppliers are the franchisee's costs and expenses to pay for.
So key documents and agreements. So within the franchise disclosure package, the franchisor must provide to prospective candidates all forms of agreements that the franchisee will be expected to sign. The franchisor can, after the fact, the cooling off period is done, present agreements for the franchisee to sign, which weren't a part of the disclosure document. The law states that all the agreements must be provided in at least a form in the disclosure document, so the franchisee has the ability to consult legal counsel and get informed by their advisors as to what the rights and obligations are under the agreement. So in the disclosure document, the key agreement is a franchise. Franchise agreement governs the relationship between a franchisor and franchisee. And we often say, look, if it's not in the franchise agreement or in the form of an amending agreement where certain terms have been negotiated in that 14-day cooling off period, that term does not exist. Salespeople may tell prospective candidates certain things on the phone. You may meet them at a trade show. But unless a franchisor is willing to put it in writing, either in the franchise agreement or in the format of an amending agreement, that term does not exist. So the franchise agreement will have terms such as what royalty amounts are paid by a franchisee, what advertising contribution a franchisee has to pay, as well as the term of the franchise agreement, what if there's a potential and possibility of renewal, what duties are there from a high-level perspective in regards to operations of a franchise, what type of advertising is the franchisee allowed to be engaged in. It has a potentially a section on proprietary trademarks as to the use and the protection of those trademarks. There's also clauses in there in regards to non-competes, non-solicits of a franchisee. It talks about confidentiality, of course. All the information is a proprietary knowledge of the franchisor that has been protected, so there would definitely be confidential provisions in there that protect the franchisor's proprietary information. There also are terms such as what happens in the event a franchisee wants to sell their business, what happens on their death and disability. As well, the franchise agreement also highlights all of the terms, the events that may lead to a termination. So whether it's a curable, whether the franchisee has X amount of days to cure a default in the agreement, or whether it leads to an automatic termination, all of that will be specified in the franchise agreement. So, and the rest of the terms are pretty general in regards to the very high level as to mediation and arbitration and the legality clauses around interpretation of the franchise agreement. Within the franchise agreement itself, there will be certain agreements that form ancillary and part of the franchise agreement. So, some of those agreements are such as the personal guarantee. Essentially, the individual behind the franchisee will personally guarantee the obligations of the franchisee under the franchise agreement. So often we get the question where from franchisees that, hey, can the personal guarantee be removed? And when we advise our franchisor clients, the market standard is a personal guarantee is required in all franchise relationships. There are odd brands where personal guarantee does not apply to so specifically as it does to the majority of brands, but that is very few and far between. Another key agreement that forms ancillary part to the franchise agreement is the general security agreement. Essentially, this allows the franchisor to take general security over the assets of the franchisee to fulfill any payment obligations of the franchisee under the franchise agreement. So if a franchisee fails to pay royalties, to pay certain funds, the franchisor has the right to realize on the assets it has secured against. In the event the franchisee wants to sell the location, the franchisee will need the franchisor to remove that PPSA security registration on their assets. The franchisor will only be agreeable to release that security interest if the franchisee has fulfilled all obligations under the franchise agreement and all payments have been made. So this essentially provides the extra layer of security to franchisors, knowing that the location cannot be sold without you removing the security interest, as well as those assets, with the exception of a bank loan, which may take first priority over the franchisor security interest, that no other party will be able to encumber the rights in priority to the franchisor's rights over the assets. Another key agreement in the franchise agreement is the sublease agreement or a lease rider concept. Depending on if the franchisor is requiring a franchisee to go directly on the head lease, in that case, a franchisor will sign a tri-party agreement, which is also called a lease rider, where the franchisor has the option, not the obligation, to take over that location in the event of a default by the franchisee or the franchisor has to terminate. This tri-party will be between the landlord, the franchisor, and the franchisee. And it's usually signed up at the time that the franchisee signs a lease, because if it's not signed up at that time, and now the franchisor wants to take over the location, a landlord may just outright refuse the franchisor from exercising any rights to that location, and the franchisor may be out of luck. So as a condition of approving that site and signing that lease, franchisors usually at that time ask the franchisee to pass on the tri-party agreement to the landlord to have it as a condition of hey, we'll take this location, but we also will require for the landlord to enter into this tri-party agreement. The alternative to the franchisee going on the head lease is the franchisor will directly go on the head lease. What this allows franchisors to do is to control all of the location from a legal perspective. If a franchisee ever defaults under the agreement, they have the right to terminate the franchisee and just simply terminate the sublease as a cross default under the franchise agreement. So the location and the lease will remain in control of the franchisor at all times. Obviously, there are pros and cons to each model. The con on this side is the franchisor will be obligated to the landlord at all times under the lease. So if the franchisee stops paying rent to the sub-landlord, which will be the franchisor still owes money to that landlord. The landlord is not going to go after the franchisee because they are not in a direct agreement. If the payments are made under the lease agreement with the franchisor, the landlord is going to come after the franchisor. So, but it allows you the control and the comfort of knowing that you won't lose prime AAA real estate, or say whether it's in a mall or a street front, knowing that it's a very good location, just that my franchisee operator wasn't good. And because of that, we lost a very good location, which is all part of the marketing and the branding of a franchise. So, but the con side, like I said, is the franchisor will have to be comfortable of fulfilling all the obligations under the head lease if a franchisee defaults under the franchise agreement or the sublease obligations to the franchisor. There are other certain supply agreements depending on the nature of the franchise. It might be a distribution agreement with third-party suppliers. Say it's in the food space, maybe in the convenience store space, where they're wholesaling a lot of product. Maybe there's POS providers, other tech companies. So there might be supply agreements that also form part of the franchise agreement. In addition to the franchise disclosure document, in Ontario, if a franchisor has an operations manual, they'll be required to attach a copy of the table of contents in the FDD document. It's not the entire operations manual because obviously the franchisee has not signed up as a candidate, so the franchisor cannot disclose that confidential information, but at least the table of contents, if an operations manual exists at the time of disclosure to that third-party candidate. So all of these key agreements form a part and parcel of the franchise agreement, which is a piece of the disclosure document. All of this is the franchise disclosure package, which a franchisor provides to prospective franchisees.
Okay, perfect timing. So we have about 15 minutes left. If anyone has any questions, I know we've gone through a lot of information, both about the legal process and the documentation that's required. We're happy to answer any questions you might have about either.
So what are the typical startup of costs is one question that has come in.
Yeah, good question. So, really what you're setting out for the franchisee is really how much is it going to cost them to start the franchise? So that initial franchise fee that we've talked about, the payments to the franchisor, your cost for equipment and furniture, your cost for your cost for any of your build out. So how much is going to cost to take a typical unit that we would expect the franchise to be located in? How much is that going to cost to build it out, right? So obviously when you walk into a Tim Hortons, you have specific flooring, you have specific walls, you have specific tables and chairs, and now fireplaces, you have menu boards, all of that stuff added up together will be part of your cost. In addition, you have to talk about how much your rent will be. Generally we expect an 800 square foot location or a 20,000 square foot location, depending on what your brand is. And that's so how much will it cost to pay for a security deposit? If you have to use a broker to find a location, typically, how much will that cost? And how much will your rent be, your insurance, your legal and accounting costs? So really everything that you'll need to get into the market. Now, this is one area that when we have when we have franchisors who are considering entering the market of franchising, that they're not sure about. And we can help you. We can give you the general categories. But if you are somebody who hasn't actually opened a location in the recent past, you may need to interact with and to bring on a consultant who can help with this. So there are many, many, many consultants who work in the area of franchising. They can help, complete your business planning. How much should you charge them? How much will they make? How much will it cost them? So all those dollar amounts, a consultant can help you. They can help you with operational decisions if you're just really not sure once you've talked through all the options with your legal counsel, what will work for you. They can also bring on a consultant who can help create your territories. How big will your territories need to be to make sure that your franchisees are successful and to make sure there's no overlapping and all of that information.
Yeah. So I see another question here. Is there a difference between the 20% deposit and the initial franchise fee? So what we mean by 20% deposit is that is the cap. That's the maximum a franchisor can require a franchisee to pay when they before they provide an FDD. So if the franchise fee is $30,000, then that 20% cap is about $6,000. But that is fully refundable to the prospective candidate. But what it allows the franchisor to do is to not have the people that are just spinning the tires and not serious. They just want to collect a bunch of disclosure documents. They actually have real candidates. Someone's actually willing to cut a check for $6,000 to pay a deposit to actually receive the disclosure document. So what is the typical cost of a franchising consultant? So that's a good question. Usually, as a part of the franchise fee, franchise consultants for the brokering piece of prospecting and locating and finding prospective candidates for a brand, it's usually between 50 to 60% of a franchise fee. So that is a franchisor that is very high. That's actually pretty market and pretty standard across the board as to what franchise brokers charge for prospecting and finding candidates. But for other services such as franchise consulting, looking at the brand and the operations and fine-tuning those pieces based on the experience of franchise consultants, that's usually going to be either based on their hourly rates or based upon the size of the project and the undertaking that the consultant is being engaged.
Yeah, there's a couple things when it comes to franchise consultants. So the first thing that Sukhdeep mentioned was brokers. That's really a different thing than a consultant. A broker is somebody who helps you bring on candidates, and they get paid only when you bring on a successful candidate. Sometimes, and often in the franchise space, a broker will also provide franchising consultancy work because they tend to really understand operational issues and whatnot. Now, in my opinion, a consultant who does brokering is typically more of a broker and not a consultant, but you can certainly find some that are great. If you hire a consultant who does brokering services, then typically those consulting services will be cheaper because you've agreed to sign on for brokering. If you're just bringing on a consultant, then yes, you typically will get a project-based fee. And if you're just getting some help with figuring out costs, obviously that's going to be lower than others. One thing I'd watch out for is that we've recently seen in the market that a lot of these consultants will say, we'll throw in the development of your franchise package and your franchise agreements. You should never have a non-lawyer put those together. In my experience, we've reviewed many, many packages that have come from those types of consultants, and they are always deficient in many ways. We have another question. What about the franchisees' IP? For example, could they develop additional values and courses in educational franchise? Want me to?
Yeah. So this is a very good question. But as a rule of thumb, whatever the franchise agreement says, it will govern. So usually, any type of IP or confidential information that has been developed on the course of the franchise, that belongs to the franchisor. However, in this certain space, I see that there could be, franchisees bring initiative as to developing certain courses. A very good example is McDonald's. When the Big Mac was created, as well as the fish fillet, it was franchisees that were given the rights to experiment and come up with this product. At the end of the day, that product was still belonged to the franchisor. So as a rule of thumb, it is what the franchise agreement says. But there may be certain terms for certain industries that a franchisor may be willing to engage or provide some type of remuneration or compensation to franchisees for maybe developing that value add. But I would say typically, all that IP from the franchisors.
The other thing that's really important to understand is that you're not going to be entitled to develop new things unless your franchise system provides for that. So, we have franchisees who sign up and they're really entrepreneurial and they come back and they say, hey, the franchisor won't let me do this. I have this great idea that would bring in some more income, and they're saying no. And the answer is, too bad. It's their brand. They get to decide what you sell, what you do, how you do it. You can think you have a really, really great idea that the franchisor will not agree with, and really what they say wins. So it's important to understand. Now that's not always the case. And certainly with the newer brands that are closer to being startups, you do have typically the franchisees may have a louder voice in terms of development. But there are lots of educational franchises. I'm going to use that example because the question came around about new courses in an educational franchise. But some franchise systems that are educational, as an example, will say, the curriculum comes from us and you are not entitled to develop other curriculum. And then, of course, there could be, it's a really, like we've said a number of times, it depends what your franchise agreement says. And that's part of that period where you're really finding out if you're a good fit. Like if you're somebody who wants to buy a franchise and become a franchisee and you want to have a voice and you want to help develop, then you need to find a brand who's open to that, because really the standard is everybody does the same thing. Every unit you walk into, you can buy a burger and look and feel and taste the same. And so you can't have franchisees all doing their own thing. It is part and parcel to a franchise. We have another question about databases for credible franchising consultants. So that's a really good question because, as I've mentioned, there are lots of really great franchise consultants. There are lots that are not very competent, in my opinion. And I would say start with the Canadian Franchise Association. They have a very good website, and they don't allow anyone to join. They have to kind of do some level of inspection and certification before you join. Franchisors can't join the CFA without having their franchise disclosure package approved kind of for general competency, as are other third-party providers. So the CFA website, Canadian Franchise Association, will have a list of their franchise lawyers, franchise accountants, franchise consultants, franchise brokers that are well known in the industry. So always a good place to start. I think that might be the, yeah, go ahead. Yeah.
One more just came in directly to me. Are franchisors and hence franchisees necessarily only for profit? Look, when we're talking about franchising, we're by and large talking about a for-profit model. Of course, the system would make sense if you were franchising a not-for-profit, maybe so in the health industry, certainly you could see that could be potentially used. You could have like a gallery or a concept, but really the idea is that it's replicated, right? So I'm thinking of charities that are in lots of locations, like community foundations, for example. Those are not considered franchises. They're considered a charitable network of community charities. I can't think of a brand offhand that would be a not-for-profit that's a franchise. I mean, part of a franchise is that, the minds are, selling and buying or selling some sort of product or service. So of course, as any business could be a not-for-profit, you could franchise a not-for-profit. But I think technically that could potentially work, but I've never seen one.
I think it goes down to the investment aspect of it. It is an investment. You are spending X to potential realize a profit at the end of the day. Like we said, I don't think it's, like Amy said, it's impossible. But from what we've seen, we haven't seen any not-for-profit franchises that exist.
Yeah, and there's a whole other world of legislation and rules that relate to charities and not-for-profits. And in my opinion, it would be very complicated to connect those two pools of legislation and make them both kind of compliant, but certainly, not impossible. So just before we go, what I wanted to say is if you want to reach out to Sukhdeep or myself, we both listed on our website, kmblaw.com. We do love to talk to potential franchisors about whether their brand, makes sense for franchising. We're happy to have a conversation, before we turn on our clock. But I really think, this is an area that's really exciting. And I think it's an area that really scares people. We've talked to so many people who say for years, I went back and forth about whether we wanted to franchise. It is an investment. Your legal fees will be somewhere in the nature of $20,000 or more to get your franchise package together. It is definitely an investment. But I do think that some people think because of the American experience, it will be hundreds of thousands in legal fees. And that's not the case in Canada. There's no, like I said, there's no certification. process, and that really cuts down on your legal costs. So, you're going to create a company, you're going to talk about trademarking and protecting your brand, and you're going to create your package. And typically you're talking about 20 or 25,000 if you're looking at one of the non-Bay Street firms. There are a number of very good franchise firms outside of Bay Street that are a little bit less expensive that can help you with these packages, obviously ourselves included. And then, like we said, then you can decide if you need to bring on a consultant or any other mechanism for assisting you, perhaps getting somebody to help you create your manual, your operations manual, or who may, somebody who wants to help you develop your trademarks. Like there's a million different kinds of consultants you can bring.
All right. Well, thank you very much to both of you for joining us, and to Kaiser Mason Ball for hosting this webinar. And thank you everyone for joining us today.